I've seen one of the YouTube videos, Phil, with your daughter saying, I think when I'm older, I'll take the money.
What would you prefer, mummy and daddy? Or would you prefer $4.5 million?
If it was in like 20 years, probably the 4.5 million.
Really?
Yeah.
Why?
First of all, make a will. I know that sounds a bit obvious. We're talking about it. But so many people I speak to of all ages don't have a will in place.
And the tragedy was, she hadn't thought to make a will.
True or false? If it's in my will, my super fund will just follow those instructions.
Yeah, false, because again, your will and your super fund are two totally separate things. What does reasonably and fairly mean when it comes to a dispute? They're really like these words.
This is why lawyers make a lot of money in estate claim. Hey there, thanks for joining us for another deep dive episode. And today we've got one of our amazing advisors, Kellie Pearce. Thanks for joining me, Kellie.
Thanks, Phil. Hi.
All right, so Kellie, talk to me. Why might millions of Aussies think they've sorted out who's getting their super money when they pass away, but they actually haven't?
Yeah, it was interesting headlines I saw, Phil, and recently on the ABC site that they're saying at least 6.5 million Australians will not have a say in who inherits their superannuation. So I thought, let's have a look at that and see if it's true. So I think what's happened is that many Australians assume that their will determine who receives their super, but that's not actually true because super is not automatically part of a person's estate, which means it's not directed by your will. And the other problem with it is that others believe that simply naming a beneficiary in a non-binding nomination, which is the easier way to do nominations, which we'll have a chat about, they think that will be what happens, but that can be what we call overridden by the trustee. And binding nominations also expire. So there's a couple of reasons there why there are millions, potentially millions of Australians who haven't got that surety of knowing who their insurance or their life cover is actually going to go to in the event that they pass away.
Awesome. So this is a perfect deep dive. And I always say to my daughters, this is why we don't assume, because it makes an ass out of you and me. So it's good that we're not assuming. We're going to talk about what a nomination is, how it all works. So, let's get stuck into that. What are we actually talking about?
When you apply or have superannuation, they'll ask you to fill in what we call a nomination. And that is because, as I mentioned just before, when you have your superannuation, it doesn't form part of your estate. So when you pass away, you've got your house and your cars and money in your bank account. That's called your estate. The superannuation is separate to that because of an act of legislation. And because it's separate, we have to tell the superannuation fund where we want that money to go. So in order to do that, we fill in what we call a nomination. We nominate where we want that money to go from the superannuation fund. And that way we can have a nomination that's binding or non-binding. So most of the online forms that we have default to non-binding nominations. So a non-binding nomination will tell the superannuation trustee, we call them the trustees, your wishes, but the trustee, so the manager effectively of that superannuation fund, still gets to decide where your superannuation benefits go if you pass away. So a trustee can consider your nomination, but they can actually override it. So if your circumstances have changed or if something happens or if someone actually challenges that, the trustee can have a look and say, look, Kellie thought that she wanted it to go to person X, but I'm going to override that and make it go to person Y. And that can be a little bit scary for people.
Yeah. And, your superannuation is probably, if not your biggest asset, but one of your biggest assets next to your house as well. So it is important that we talk about it and talk about, how do we manage this? So let's just talk about nominations. So can you quickly define like a super death benefit and who can legally be paid those super funds?
Yeah, you'd think that'd be easy, wouldn't you? And I used to work for an industry super fund and we'd see lots of these that came through that were actually incorrect because a super death benefit is the money that's paid out from your superannuation fund when you die. So it includes your super account balance plus any life insurance, which is where we come in with life insurance. So under the SIS law, which is the Superannuation Industry Supervision. Actually, that's a mouthful, the SIS law.
Yeah, you got there, yeah.
Yeah, got there. Your super death benefit can only be paid to certain people. So they are what they consider to be your dependents. So your dependents include your spouse or your de facto partner, so your husband or wife or de facto partner, your children. Now, that's children of any age. So, your children could be 60, but 70 plus by the time you pass away. In fact, I had someone who was in their 80s who received something because their parents were in their hundreds. So that's fantastic. So children of any age. Can also be someone who's financially dependent upon you, which starts to get a little bit grey, or anyone with whom you've had what they call an interdependency relationship. So you've shared a life or domestic support or something. So that's under the SIS Act. Or if you haven't got someone directly, you can nominate someone as what we call your legal personal representative, which means it goes to your estate or your will. What you can't nominate there under all those dependents usually are your parents. So when I worked for an industry super fund, we'd see the forms come in all the time, and they young people particularly, they're not in a partner, they haven't got their kids yet, so that it makes it a little bit harder, and they nominate their parents because they think their parents, quite rightly, are their most nearest and dearest. But as it turns out, you can't actually nominate your parents, and you can't nominate Uncle Joe and Auntie Mary because they don't qualify under this SIS Act. So it does get a little bit complicated. So it has to be people who are specifically nominated under the SIS Act. So just to make it a little bit more complicated.
And there is a little bit of a definition where you talk about a financial dependent. Now, if you have elderly parents who are financially dependent on you, then they may be, SIS dependents, SIS Act dependents. But for most, early 20-year-olds, the parents aren't financially dependent on that 20-year-old being around, and so therefore, they can't get paid out. So you did say earlier that the estate won't get the super benefits. Now, that doesn't mean that the estate can't get the super benefits. So, talk to me about that. You kind of mentioned it about, your legal representative. But if I want my will to dictate where my super money goes, how do I go about doing that?
Yeah, good question, Phil. First of all, make a will. I know that sounds a bit obvious. We're talking about it, but so many people I speak to of all ages don't have a will in place. So number one, if you want it to not, you've got your superannuation benefit and it needs to go to someone who doesn't qualify directly under that SIS Act. So you nominate the legal personal representative and you want it to go to your will, you need to have a will in place. Otherwise it gets really messy. So, and the other option, as I just mentioned, is you can nominate what they call as your legal personal representative, and that means your benefits will be distributed as according to your will. But let's put a will in place. That's a really important reason why we should be having a will in place. Even
do you have a will, Kelly?
I most certainly do. Phil, do you have a will?
Good, I do. It actually took us a while to get one set up because we got one after we had the kids. Yeah. And it took us so long because we're trying to think, who do we want our kids to be looked after?
Yeah.
Me and Kate are both the youngest of 5 kids. So we've got plenty of siblings, plenty of parents, our parents are starting to age. So that was the hardest thing for us when forming will is how do we decide that? But also, we have allocated our estate to access our super benefits because then we want our will to, it's not overly complex, but set up, trust in, if we pass away because we don't want our girls to have access to it, easily. So we've added a little bit more complication, which to be honest, it's not that complicated for us. You may charge a few $100s extra to set it up. And it just gets managed when we're dead. So I'm not around to deal with the extra complexity of it.
I've seen one of the YouTube videos, Phil, with your daughter saying how much she,
she's well aware.
The money. So I think when I'm older, I'll take the money. So I can understand why you've put a few more caveats.
Exactly. Yeah, it wasn't after that, but I'm well aware of my children are very similar to me. So, we've put some caveats. So, we're talking about superannuations, we're talking about wills, but at Skye, we deal with insurance. So talk to me, how does this have anything to do with life insurance?
Yeah, so what happens is if you come and see us and you take out insurance for yourself. So, and we've covered these in lots of deep dives, but total and permanent disability insurance, if you get a payout, and as part of that, we often what we call link life to that. So you will often receive, if you're unfortunate enough to need it, your family, you will receive a lump sum life benefit, and it's often more than $1 million. So that if a person with that cover is unfortunate enough to pass away, that amount will get paid from the insurer into the superannuation fund, because that's how we tend to set it up for most of our clients, is that the insurance will be paid for from their superannuation. So that actually means, without trying to get too complicated, that the superannuation owns the policy, and therefore that's where the benefit will get paid into.
Yeah.
So if the superannuation fund receives a lump sum of money, let's say $1 million, then they'll look to see, well, who is set up to receive the money from that. So the insurer pays the money out because someone's passed away, but it goes into the super fund, so not directly to the families. So that's why if you pass away, you need to make sure that the super fund has the right nominations in place, not the actual insurance who you've taken the actual insurance out with. So it's not the insurance company's responsibility.
Yeah. And the other thing is, if you do set up your life insurance and you pay it directly to the insurance company and you own it personally, so on your policy it'll say the life insured will be your name, and it'll say the owner, which will be the super fund. When we set it up, we generally get the life insurance paid through the super fund because it's tax effective and it's a good structure. But if you are the owner, if you're listed as the owner, then the money will get paid out to us directly. So we don't need to worry about any of these nominations.
That's right.
So we are going to talk about, insurance policies and super funds, regardless of that bucket of money that's left over when someone passes away. What happens to that? So let's start with the bad. So a non-binding nomination and trustee discretion. So talk to me, what exactly is a non-binding nomination and why can it be, almost like not ideal or useless in a dispute?
Yeah, so we love our jargon, don't we, Phil? So a non-binding superannuation is the most common because it's the easy one. And it's when a member tells the super fund who they prefer to receive their death benefit. But the fund's actually not legally required to follow that. So you would receive a form and you can just choose non-binding. And it's the reason people do this is because it's relatively easy, because you can just nominate a person, sign it and send it in. It doesn't need to be what we call witnessed, which we'll get to with the binding nomination. So the reason that we're saying that it's kind of useless, and this is what part of the 6.5 million Australians was not having that certainty of potentially where their money's going to go, is because that opens it to what we call trustees' discretion. So the super fund has the final say. So if there's a disagreement amongst potential beneficiaries, the trustee thinks the nomination doesn't reflect the member's best interest, then the trustee can override it. So, for example, Phil, you've got 3 girls.
Yeah.
And let's say you had yours set up this way. I know you haven't. You just told me you've got it set up. You will just say that you had given money to your oldest daughter. This is 20 years' time to help her buy her first home. So you'd already gifted her, $1 million it'll need to be by then.
Yeah, exactly. Yeah, but
so,
would be nice. I'd love to be able to gift them $1 million. So that's nice of me.
Yeah, but relative.
To any of my daughters out there watching, you're not getting $1 million to buy a house. I'm sorry.
Girls.
I love you, but I love you in different ways.
So, and the idea would be then potentially your other 2 daughters could say, hey, that's not fair because we didn't get that $1 million. Therefore, we don't want dad's super inheritance money, so from your life insurance, to be split equally 3 ways. So they could actually put in a disagreement. So that's what a trustee could override that. So there's no legal guarantee with a non-binding nomination that that's where your money's going to go. It's up down to the trustee. So if there's a family dispute, and one of the ones that I saw on that article that I was reading was an uncle actually made a dispute saying that he thought that he had some claim to the money. So it does open it up that family members or maybe a close neighbour who was looking after, someone closely could put a dispute in. So a non-binding is not, locked tight.
Okay, so in reality, when there is like a fight or a dispute over the money, what does a trustee actually do with the money? How do they make a decision?
The trustee can review the decisions if someone can dispute how the death benefit was allocated. So they can look to see that it was on the correct form, that the beneficiaries, and if they don't think that it was legally eligible, if the person wasn't legally eligible, something they can override that decision. So they have to collect all of that information. They can determine who's legally eligible. they can exercise then that discretion over who they think is more eligible to receive it. And then at some point they will attempt resolution to ensure that everyone's happy. But it's rarely, if there's a dispute, that everyone's happy.
Yeah. And so trustees, people can take a trustee to AFCA as the Australian Financial Complaints Authority. Yes, I got that acronym right. So they can take a trustee to AFCA if they disagree. So how does the trustee deal with an AFCA dispute when it comes to non-binding nominations?
So AFCA can have a look at it. So they can review the trustee's decision if someone disputes how the death benefit was allocated. So they can request that the trustee, the superannuation fund trustee, reconsider, or they can confirm or vary the trustee's decision, but AFCA cannot force a payment contrary to law. So they cannot override the legal restrictions on eligible beneficiaries, and they have to check if the trustee exercised that discretion reasonably and fairly. But what does reasonably and fairly mean when it comes to a dispute? They're really loose words.
This is why lawyers make a lot of money in estate claims.
Yeah.
So let's talk about lapsing or invalid binding nominations. So we've set up a binding nomination, all good, but we've gone and realised, that nomination was actually invalid or it lapsed. So to talk us through, first of all, what is a binding nomination? How do we go about doing it? And then, what happens if it's invalid?
Yeah, so binding nomination is sometimes on the same form, sometimes a separate form, where the member, the person who owns the fund, has to choose a binding nomination, and they have to fill in the correct form. They have to ensure that the beneficiaries are eligible. So again, going back to what we were saying earlier about being a dependent, being children or a spouse, are effectively mainly the people who are eligible, not Uncle Joe and Auntie Mary. But importantly, really importantly, it has to be signed and witnessed by two eligible witnesses. And again, don't we love the law and eligibility of witnesses? So the eligible witnesses have to be 18 or over, and they cannot be the beneficiaries. So they cannot be anyone who would be, so children, generally, if they're going to be the beneficiaries, can't sign that form. So it needs to be a neighbour and someone who's mentally capable to do that. Also, interestingly, most binding nominations have a 3-year expiry date. So they have to be eligible. A binding death nomination usually needs to have been signed within 3 years. And that's also a cause of concern for people, because often they did one 10 years ago and they've forgotten all about it. For whatever reason, the fund hasn't told them, or they didn't read the notification, and they don't realise that their binding nomination is now no longer binding because it's more than 3 years old. So that can be another big issue. So wet signatures, clear instructions, and then you have to actually get notification from the fund. You post it all in, go snail mail for most of them still these days. They're not done electronically online. And the fund has to actually acknowledge that they've received it. So, mail gets lost, things go wrong, all sorts of things. So there's lots of reasons why you might think that you've got a binding death nomination in place, but you actually haven't. So
and the reason for lapsing as well, because once a binding nomination is all done, making sure it's going to a superannuation dependent and making sure that there are two valid witnesses and all of the checks and balances are done, the trustee has no discretion. So if I do a binding nomination, nominate Kate, my wife, and then, we get a divorce. I love you, Kate. That won't happen. And then I get remarried. And that binding nomination is locked in. It can't change, even if you wanted to nominate someone else. So that is why there is a lapsing feature, because if I did a binding nomination 20 years ago, is it likely to still be valid? Probably not. And so that's why it is painful. It is annoying, but at least it does have some protection mechanisms for the superannuation members.
Yeah, and that's where it's quite different from a will too, which comes back to potentially why I feel it was a really good idea to set yours up through your legal personal representative, which means it goes to your estate as per your will, because your will not expire after 3 years, whereas a binding nomination, whilst it was all watertight and everything, after 3 years it will expire because of marriages and divorces and deaths and births and all sorts of things do tend to change. So that's why most of the funds have that 3-year expiry.
Yeah.
I don't think that's part of the SIS Act. I think that's just the fund's discretion that's how they.
I think so. Yeah. So let's talk about the good reasons. Why are we doing it? Why should we do it? Yeah. Why are you telling me I need to have a binding nomination on my super fund?
Well, if you want certainty as to where your superannuation money is going to go, and again coming back to the reason we're doing this, it's not just the balance of your super fund. You might only have 50 or 60,000. You think, I don't care, but you might have insurances, so it might be several million. If you want some certainty as to where that's going to go, a binding death nomination is the way to put that in place. Sign the form, have it witnessed, send it in and get it acknowledged. Yeah, it's going to take an extra 15 or 20 minutes, potentially, maybe even a couple of hours, but the certainty is what's important.
Yeah. And so I will, I'll hit you with some mythbusters, true or false, in a second. But the other thing to think about is, the way in which we set up insurance policies is we set up an external super fund to your main super fund. And even though your main super fund is paying the premiums of that policy, you technically have two separate super funds. So you need to make sure that if you want your superannuation assets to go, and you want to make a binding nomination for your superannuation assets, but you set it up via external rollover for your insurance policies, you need to set up two separate binding nominations across both of them. So one for your super fund that just kind of houses your insurance policy, and then one for your investment assets that you're investing. So it is important to understand how your insurance is set up and how it links to super. So your super fund is paying for it, but it is in and of itself a separate super fund.
Yeah, it does. It gets a little bit technical. So just if you need a hand, that's what we're here for. So certainly reach out to your advisor who helped you put it in place.
Yeah. Cool. All right. So we've got some mythbuster questions, lightning round. So true or false? If it's in my will, my super fund will just follow those instructions.
Yeah, false, because again, your will and your super fund are two totally separate things. So just because it's in your will, it doesn't mean that your super fund has to follow it at all.
All right. True or false? A non-binding nomination is fine. The trustee will just honour it.
No, that's not true either. As we've just discussed, a non-binding nomination is a guide, but it's ultimately the trustee of the super fund can decide where your funds are going to go.
All right. True or false? I did a binding nomination once. It never expires.
Oh, I need one of these. Noises even think. So I did a binding nomination once. It never expires. No, that's not true. Most of them expire after 3 years.
All right, true or false? I can name anyone I want as my beneficiary, even my cat.
What? You haven't got a cat, Phil?
I don't have a cat, but this is a hypothetical true or false.
Okay, all right. Yeah, I need my little hard quiz noise or something.
Yeah.
No, you can't name anyone. You have to name people as per the SIS Act. If you want, it's a Superannuation Industry Supervision Act. If you want to go outside of that, put it in your LPR, your legal personal representative, and put it in your will. Then you can name anyone.
All right, true or false? Me and my brother, we can go and talk to my parents. I'm one of 5 kids. We can go to my parents and say, Mum and Dad, nominate all of your money to come to us, all your superannuation money to come to us, and we'll witness that document, and that's legally binding.
Yep. Again, no, beneficiaries, people who are going to be beneficiaries of the superannuation cannot witness that binding nomination. So they were all false on our kids.
Yeah. All right. We're done for the true and false. And we'll send up a big air horn for the next time we do this. Yeah, that'd be good.
Thanks, Phil.
I don't know what the correct answer would be. Like maybe a bell, like a ding.
Oh,
or
yeah.
a big air horn if it's wrong. All right, Kelly, let's wrap this up and go through like a practical checklist. So what is like a few steps that we can go through to make sure the people watching this video have got this all sorted out?
All right. Correct form. Make sure it is the correct form and that you're ticking, if you want the certainty, that you tick the binding nomination. Make sure that the beneficiaries are eligible. So as we've mentioned, it be your spouse, usually your spouse and your children. There can be a little bit of variation from that, but generally speaking, if you want it to be your parents or something like that, it has to go by your will. So make sure that the beneficiaries are eligible. Make sure that you've signed the form and that your witnesses witness it and sign the form. And actually another one we used to get when I was at the super fund, all on the same day. So they have to actually see you sign the form on the same day, preferably with the same pen, and so that there's no element of dispute, and that they see it all and they sign it all on the same day. I know that sounds obvious, but it's not. Some people get their neighbour to witness it after they've signed it. So it all has to be on the same day at the same time. That your beneficiary nomination is within 3 years of age, that it's clear so they can actually, the trustee can see who it's printed out to. So preferably pre-fill the form and have it signed, because you wouldn't believe how many times people can't read handwriting and things like that. And make sure finally that the fund acknowledges that they've received it and all of those things are in line. Simples, Phil. I don't know why people ever get it wrong.
All right. Last question for you before we wrap up. If someone watching this video has realised, oh, I did that nomination a few years ago, my life situation's changed, or actually I nominated my parents and now I know they're not eligible, what should they go about doing this week?
Yeah, so we can, if they put it in their insurance in place with us, we can reach out and double check for you. If you're not sure, reach out to your superannuation fund. They've all got helplines, they've all got people there, and they'll all be able to check for you quite quickly and easily who your beneficiaries are.
And often your super statements will have a beneficiary as well, or your insurance policies will have beneficiaries nominated. So again, yes. I guess my one reminder is noting that sometimes if you've set up your insurance to be paid via an external rollover and an external super fund, that means you've got to do two separate nominations, one for your investments and one for your life insurance policy.
Yeah, really important point to note, because a lot of people forget that.
Yeah, awesome. Thank you, Kellie. I really appreciate it. Is there anything else that we haven't touched on that you think is important to note, or anything else that you kind of want to mention before we finish up?
No, I think that's it, Phil. As we said, get a will in place. That's really important as part of, it's a part A and a part B, but also just checking those forms. And if you're not sure, reach out to us. That's what we're here for. We love ensuring that if everything, that's why we put it in place. If something ever happens and you need your plan B, we want to make sure that your plan B is going to go where you want it to. It's really important.
Yeah, exactly. Awesome. Well, thank you, Kellie. I really appreciate you taking us through the different nominations. This is such a boring topic, but incredibly important to make sure we do it properly. And yeah, you don't want to stuff this up, because you can't change it after the fact.
Yeah, that's it.
So thank you very much. And thank you everyone for watching. If you did enjoy this, there will be some other deep dives on the screen now. Thanks again.
Thank you.